Question: how do porcupines make love? Answer: very carefully. How do American professors talk about race-related issues and gender-related issues? Very carefully. Beyond the humor of the joke, which I hope defenders of porcupines will not find offensive, it is the case that the gender issues, which we'll speak about in a later seminar, and race-related issues, which is the initial topic this afternoon, are extremely important, are extremely central to any discussion of politics in the United States, and indeed raise many sensitivities and sensibilities in all of us, quite regardless of our gender or of our ethnic identity. I chose as the title for this afternoon's talk something about race as an American dilemma, thereby pirating the title from the extremely well-known work of the Swedish sociologist Professor Gunnar Myrdal, who suggested that race relations and race discrimination were peculiarly an American dilemma because of America's other kinds of commitments as to notions of equality and justice. I am going to use some simple-minded legal development analysis to raise with you a host of questions, and then I am going to wrap up this particular seminar by putting to you a series of cases for you to think about today and even beyond today. To do all of American social history in the next 20 minutes is a bit much even for me, and yet I think it's important to get the swift survey of the issues. I use legal materials because that's what I know something about, and some of them will be quite famous, and those of you who do not work in this area will recognize them also. So where to start? The initial legal status of black persons in the United States was as chattel slaves. A chattel is a thing like a bale of cotton, and there are rules in law for what happens if I buy cotton from you and it arrives defective because it got wet in the boat or something like that, and there are rules in law that deal with the status of chattel and the responsibility of chattel, and there are even good ones which I haven't looked up in a long time in contract law about if I buy a cow from you and she turns out to be pregnant and neither one of us knew it, who gets the baby calf. That's how black people were treated, as if roughly analogous to a bale of cotton, or indeed to an animal. Chattel slavery was the beginning of the black experience in the United States. We have not too long ago celebrated the 200th anniversary of the American Constitution. At that time, when all of us were busy glorifying the American Constitution, the then Justice Thurgood Marshall allowed himself in a speech that there was a lot of ugly stuff in the original Constitution vis-a-vis black people, and there indeed truly was. Maybe not since high school have you thought about the 3/5 compromise. Black persons were 3/5 of a human being for purposes of apportionment in Congress and for certain taxing reasons. One interesting mechanism for dealing with a highly controversial political topic is to agree not to put it on the agenda. And that was done in the Constitutional Convention by setting a date before which it would not be possible for the federal government to prohibit the importation of slaves. That sounds like a really quick compromise, the wisdom of America, right? There were free states, there were slave states, they cut a deal. The deal is we'll do ours, you'll do yours, and we won't let the central government look. What could be better than a deal like that for all of us? As long as, of course, you don't count the black slaves as part of the bargain. But you do understand. Chattel slavery, and then into a constitutional status that counted them as 3/5 of a human being. Comes now the Civil War, which is quite beyond my purposes, and the extent to which the Civil War is best understood as an economic phenomenon, or is best understood in terms of the power of ideas, that you will have to study with other people. After the Civil War, there emerged in the law 3 new amendments to the Constitution, 13, 14, and 15, which, if you would, with me, think back to junior high school or so, the 13th Amendment eliminated slavery. That was easy. The 14th Amendment, I'll skip for a minute. The 15th Amendment gave the newly freed slaves the vote. That's also easy to remember and to understand. And then there was this 14th Amendment, which is long about in junior high school, and you may have had a richer experience than I did. Long about in junior high school, it said something about citizenship or gave them rights. The high school teacher didn't know, and we didn't know, and The 14th Amendment of the Federal Constitution is by far and away the most important text having to do with what you would call civil rights or civil liberties, certainly vis-a-vis the national government. And it has a number of great and powerful clauses. The Privileges and Immunities Clause, which was struck down dead by the Supreme Court in the 19th century, in the late 19th century. The Due Process Clause, which is extraordinarily important but is beyond my purposes today. And the one that I need, the Equal Protection Clause. No state shall deny to any person the equal protection of the law. No state shall deny the equal protection of the law. So notice right away, and we may have discussed this in an earlier seminar, notice right away the attention on no state shall. Whatever it was that couldn't be done, it was the government who couldn't do it. And the state government under the 14th Amendment. In Bowling and Sharp, one of the cases that comes down with Brown versus Board, I'm showing off for the lawyers. In Bowling versus Sharp, one of the cases that comes down with Brown versus Board, that is held to be equally applicable to the federal government. How that is possible and works is beyond this seminar. There is a great deal which is beyond this seminar. No state may deny a person the equal protection of the law. That strongly suggests that non-state action, private people, can deny equal protection, whatever that means. And you might begin to think again about something which I believe I touched on earlier with this group, and that is the distinction, if there is one, between public acts and private acts. When the government does things and when private people do things, how much does it matter, and when is it private people? And we will talk a little about that either now or in the subsequent 45-minute lecture. No state shall deny the equal protection of the law. The dominant posture of the status of black people in the United States up to the end of the 19th century and beyond is nicely captured in C. Van Woodward's title of a wonderful and important book which is available in paperback, The Strange Career of Jim Crow. Many of us in this room now remember explicit Jim Crow segregation laws. I have a vivid memory of going with a Boy Scout group to Luray Caverns, Virginia. A highly good place to visit, by the way. I don't get a commission, but I recommend it. And there was a picnic area. And this was in about 1956. And it had a big sign on it that said, whites only. And all of us New York City Boy Scout types took pictures of that. And we thought it was kind of funny and kind of queer and kind of odd. 2 years after Brown, I'm sure it was later than the school desegregation case. Whites only in the picnic area. One of the things that captures is the extent to which many thought that racial segregation was a southern problem as distinct from a national problem. And you might reflect on that as we go forward into other kinds of materials. Brown versus the Board of Education, 1954. Separation is inherently unequal. Repudiating the doctrine in Plessy versus Ferguson at the end of the previous century, that separate but equal would satisfactorily meet the constitutional standard. The issue in Plessy versus Ferguson was trains, and there was a mandatory racial segregation in railroad trains. And the Supreme Court, with one dissent, the United States Supreme Court, held that there was no denial of equal protection simply because one car on the train was marked for blacks or coloreds or whatever the word would have been then, and the other was for whites. Said one of the justices with scorn, the train arrives in the station at the same time, whether you're sitting in the front car or the back car. Separate but equal. A prescient dissent arguing that the stigma associated with being forced to sit in one car rather than another more than overcame the equality of the arrival of the train at a certain time at the Union Station or wherever. Separate but equal. And into the present century, litigation, most notably the National Association for the Advancement of Colored People, the NAACP's Legal Defense Fund, known as the Inc. Fund, headed over much of this time by a very distinguished lawyer, Thurgood Marshall, recently retired from the Supreme Court, began litigating on lots of specific fact patterns to show that separate wasn't really equal. So there was and this one I'm not making up in light of current events, there was a litigation that came out of the law school at the University of Oklahoma. True story. The state created a separate law school for a handful of black applicants, and the main deal law school was the white law school. And the Supreme Court took a subtle and sophisticated view of what constituted equality. Was there an alumni network to help the graduates of the all-black little school get jobs? Was the library comparable? Was the status in terms of getting clerkships? And in the separate was shown there not to be equal in a law school. What about education in general? Interestingly, strategically, the NAACP was confronted with the issue of whether to attack segregation head-on or to argue, which would easily have been arguable, that the facilities afforded to black children under segregation were despicable, as no running water, no toilets, no floors. I mean, really despicable, no certified teachers. The Supreme Court of the United States in 1954 held separate schools are inherently unequal. We'll come back and we'll talk about that. When separate, and under what context separate is inherently unequal. And so the Supreme Court sat back waiting for the country to comply happily, and the country did not comply happily, and there was in the South what has come to be called massive resistance, and Prince Edward County closed its public schools completely rather than integrate them, and there were private school substitutes and all kinds of stuff like that. Key point. The modern period, for us and a little earlier than for us, knew what the bad guy was. The bad guy was racial segregation. Negroes to the back of the bus. Racial segregation. And the good guy position was integration. And the assumption, which has of course proven to be painfully wrong, was that once one eliminated governmental mandated segregation, the sheriff would arrest the black person if she sat in the front of the bus, or I guess ate at that picnic area near the caverns that I referred to earlier. The assumption was that once the sheriff got out of the way, legally enforced separation would disappear and we would then have integration. So, for example, when I, in the early 60s, was applying to graduate schools in political science in a variety of places, there would be a note on the application form that said something like, you need not submit a photograph with this application. Where if we accept you, we will need a photograph for the yearbook or what, some kind of thing. What was the point? The point obviously was, we don't want to know what color you are. We don't want to know what color you are. Integration. Integration was the model of the way things ought to be going in the United States. The assumption was the reason we hadn't had integration prior to that was because and only because of state-imposed segregation. And it's worth remembering how complete that segregation was. Separate Bibles in courtrooms so that a white witness wouldn't have to touch or kiss a Bible that had been sworn on by a black witness. The total lack of dignity in that judicial proceeding for the black witness or other person in the proceedings who would never be called or frequently not be called by a last name, never given the courtesy of Mr. Smith or Miss Smith, as opposed to, well, Mary, tell us what happened. The strange career of Jim Crow, restrooms and businesses, and you know, and if you don't know, you should be reminded, and if our children don't know, they should be reminded also. The good guy position was going to be, as defined in earlier meetings of this seminar, liberal individualism. Don't judge the book by the color of its cover. Don't judge the person by the color of his/her skin. I remember when I was a kid, my mother got us some sort of a children's record, probably a 78, that's how old I am. My mother got us a children's record which said something like, black cows and white cows all give the same milk. The political philosophy of that approach is that segregation, separation is a bad thing. It's an expensive thing. You lose out on all the good milk from the black cow. And it's unfair, and it's inappropriate, and we got to stop looking at cows and people as having one color or another color because that hurts people, and because it's inefficient, and because it's the bad way, and because of the stigma The dissenting opinion in Plessy and Ferguson really emerges in the modern period. The stigma of saying you can't apply here or you can't sit here on a train or on a bus or whatever violated the fundamental norm. Equality meant measure me on the merits when I applied to graduate school and don't worry about the color of my skin. All right? So I have now done all of legal history relevant to race down to the modern period. Let me talk a little bit about equal protection in other contexts under the 14th Amendment and then put it together with race, and then the discussion will continue as we have suggested. I will talk to you about the great Rhode Island case of Barbarian versus Pettit. At least once in your life you should know one opinion from the Supreme Court of Rhode Island, and this is as good a time as any. In the great case of Barbarian versus Pettit, Pettit was some official in the Registry of Motor Vehicles, driver's licenses. Barbarian was a 14-year-old kid who was tall, and I've never seen him, but who was big for his age, and appeared at the registry and said, I want to take the driver's test. And they said, birth certificate. And he had a birth certificate, and it said about 14 years old or something like that. And they said, goodbye, come back when you're 16. And he says, that is a denial of equal protection. People over 14, people under 14, why, O Registry of Motor Vehicles, are you doing this to me? I'm emphasizing the language a bit. You are wondering how the hell such a case ever came. A Barbarian had a father who was a lawyer who enjoyed litigating stuff of interest. That's more or less true. But the case goes forward and comes down in the United States, in the, Rhode Island Supreme Court. Not too surprising, even though in Rhode Island these days one wonders what would surprise you, but not too surprising, the kid loses. But now what's going on here? The court acknowledges that drawing a line at any age for being able to take a driver's test, remember, he doesn't say give me a license, he says let me take the test. He says I'm big enough that I can see over the wheel and I can handle the shift with alacrity and all kinds of stuff like that. Just give me the test and you will see. The government comes in and says a couple of things. It says whatever one would say about young Barbarian, most kids below a certain age are too small to be trusted with a heavy-duty piece of machinery, and it's administratively very inconvenient to have to figure out which ones. But beyond that, can the kid see over the wheel? Beyond that, there is the issue of maturity of judgment. Is he going to go drag racing? Is he going to shoot stoplights in a crazy way? How do you test, says the state in its defense, how do you test for good judgment or subtlety of good judgment, not being a jerk when you're behind the wheel? And, says the government, in our experience, age roughly correlates with sensibility or sensitivity or capacity to handle machinery and to be trusted. Not everyone. The lawyer's language is over-inclusive and under-inclusive. Says Barbarian, but now notice, I am entitled to be treated as an individual. I don't care if every other 14-year-old in the state is a jerk. I'm not. I don't care if every other 14-year-old in the state is too small to see the gear shift. I'm not. I, Barbarian, am entitled, under the Equal Protection Clause of the 14th Amendment, to be treated equally on the basis of my capacities and my skills. Give me a test that will adequately meet your legitimate state need. The state Supreme Court, in an absolutely conventional and non-controversial analysis, says there has to be a reasonable connection between what the state wants to do, driver safety, and the hoops that the state sets up for the candidate to jump through, or the steps, better, that the state puts in the path of each of the candidates. It is reasonable to relate maturity and driver safety, says the state Supreme Court, to age. Reasonable. Are there some older folks who will make lousy drivers? Yeah, this distinction is under-inclusive. Are there some 15, 14-year-olds? I think the cutoff age was 16. Are there some 14, 15-year-olds who really could drive very well and very maturely and we would all trust? There are. The state doesn't have really a good way to find out who they are and to identify them. What I'm giving you is a reasonableness analysis of the 14th Amendment. When the state uses a group category, that's a notion you want to hang on to. When the state uses a group category, kids under 16, kids over 16, a group category, to predict to an unknown factor, e.g., to predict to maturity behind the wheel, there needs to be a reasonable relationship. If the state were to say Republicans can have driving licenses at the age of 14 and Democrats have to wait till they're 17, that would not, I think, be upheld as reasonable the way that would be arbitrary and capricious, or some kind of phrase like that. So now you know a standard equal protection analysis. Equal doesn't mean the same. Blind people may not drive cars. Sighted people may drive cars. That is a distinction. It is clearly a constitutional distinction. It would not be constitutional on this view to say blind people can't vote because, for example, they can't read the daily newspaper to become informed. That would be, I'm quite sure, unreasonably linking up knowledge about politics to blindness, since a blind person with Braille or with radio or with the assistance of a reader, you hear what I'm doing. Reasonable connection between that which we can know, we can test, or we can get your age, we can do a vision test, we can get your age. Reasonable connection between the group characteristic, blind persons, sighted persons, younger persons, older persons. There has to be a reasonable connection between the use of the group characteristic by government and the unknown but legitimate the purpose of the government, which is to get at unknown but important information, potential for driver safety. I'll give you one more quickie just to show you the standard analysis. In many states, I believe it's true in Rhode Island also, in many states there's a requirement to have your eyes examined for a driver's license, for example, every 3 years or every 5 years. And at least in Rhode Island, perhaps where you all come from, after a certain threshold age is crossed, like age 70, you have to get your vision checked once a year, not once every 5 years. Is that over-inclusive? Of course it is. There are some people whose eyes deteriorated after the first 5-year examination at age 30. Is it under-inclusive? Sure it is. It's both under and over-inclusive. It is reasonably related. That is to say, the judgment that older folks ought to have their vision checked more frequently is reasonably related to the state's interest in traffic safety. So now you know all that there is to know about conventional 14th Amendment equal protection law. If the state wants to treat you as a member of a group, it has to have a good reason. But some groups don't fit the discussion, is the way the law has moved. Some groups do not fit the discussion. And in particular, race does not fit the discussion. And race is understood as an inherently suspect classification. What is good enough to justify the state treating you all, us all, differently, over 70 and below 70, over 16 and below 16, there are many, many more standard examples, is the state's administrative convenience, the reasonableness of what the state is doing, does not justify treating persons differently on the basis of a group characteristic called race. That is highly suspect. Now, why should that be so? One reason that appears in the literature as to why that should be so is because of the historical abuse of persons in contexts where race was used. If people were given different access to governmental benefits on the basis of race, it always was the black group that got the short end of the lollipop. And of course, I mean, much worse than that, a history of lynchings in this country. So we have bad historical experience with the use of race as an organizing category. Beyond that, beyond the historical use that makes us suspicious, there is the notion that it is profoundly unfair to treat someone, and then the cases will say things like of a characteristic which is immutable, on the basis of a characteristic which is immutable. Being blind is immutable also, and the case law isn't so helpful in telling me why it's more unfair to treat people on the basis of race than on the basis of sightedness, even though historically I may understand that this group has been treated in a peculiarly crummy way. But it is an immutable, non-changeable. He couldn't decide for himself. You'll see in a few minutes why that gets important. And it's unfair in the sense of stigma. Stigma. In the 1940, late 40s, one of my cousins was answering the telephone, and she said to her friend, "The cleaning woman is here today. I can't come out and play." And and she said, "No, the colored girl is here today. I can't come out and play." The woman who cleaned in the household of my aunt quit as a result of that. And I heard that story, and I didn't understand what I was being told. The colored girl is here. See, she hadn't said nigger. Our parents had taught us not to say disreputable racial slurs like nigger. So the little chocolate candies that some of you may be old enough to remember, that was sort of a fudge in the shape of little children, which some of my friends called nigger babies, and we were told to call colored babies, because you don't make fun of somebody else. And I didn't understand why the cleaning person left when she was called the colored girl. She hadn't been called. I mean, I'm embarrassed to tell you this story, but that is sort of out of the late 40s. The colored girl always meant the maid. It never meant the bank vice president here to handle your stock portfolio. Not that we had stock portfolios in those days. But the colored girl always meant the one in a lesser status. Or words like boy. I mean, in my lifetime, to see an elderly black porter being asked by a yuppie-dressed guy, either, "Granddad, can you get my bag for me?" Which is nicer, he would have thought, than "Boy, get my bag." Stigmatization. That's why the history is extremely important. So when students say, "Yeah, but what happens if you set up a group for redheads and can you discriminate?" That's nonsense. Redheads in America have not suffered in the way that black persons in America have suffered. The history is significantly different. At least that is the way an argument would go. So where I have got us up to thus far is 1954, Brown versus Board. Separate is inherently unequal for these kinds of reasons. Stigmatization. And then we were supposed to move happily along with the Supreme Court's phrase you will remember, "with all deliberate speed." Not so speedy anyway, maybe a lot of deliberation. Began to be reputable voices in the body politic which said, if your goal is an integrated society, you cannot get there through colorblind methodology. Again, if your goal is an egalitarian society, you cannot get there through colorblind interventions. And the late Whitney Young, then president of the Urban League, said things like, or gave a metaphor which was taken into political discussion like, imagine a track where track runners are running, and imagine that one group has been excluded by race from ever being allowed to run. And imagine further that the group that's been excluded doesn't have any sneakers. And imagine further that they have a sandbag tied to their leg because of the history of how they have been treated. Now comes somebody and says, you got to let that group compete equally with other runners on the track with a sandbag tied to his foot and with no sneakers and with no coaching. And said Whitney Young, it is necessary to have color-conscious remedies to get us to the point of a color-blind society. I could develop that at some length. I hope I've said enough for you to have an understanding of it. The goal was Sesame Street. That's not a joke. Sesame Street was devised in large part to provide role models of a certain sort. Kermit the Frog. It's not easy being green. That's what this is about. It's not easy being green. And you got to know that if people have been treated badly because of their race for all these years, just saying, well, we're not going to treat you badly anymore and you can come to Harvard and take nuclear physics also, isn't going to respond to the differences that have been imposed. So the Whitney Young position, as I'm quickly identifying it, is the ultimate goal is a colorblind society. The ultimate goal is black cows and white cows both give the same milk, but you're not going to get there unless you have a methodology which is conscious of race. And language like role models, for example. There was another point of view on the same issue of group characteristics. A position with words like black pride, black nationalism, names like the Black Muslim movement, the then Honorable Elijah Muhammad, and his premier minister, of course, Malcolm X. The paperback version of the autobiography of Malcolm X is worth reading if one has lost touch with the anger of this period. There came a principled position in portions of the black community that we don't want the integration. Our goal is not integration. We want our piece of the action. We want our percent. We want to know how many black judges there are on the court. We want to know how many black-owned businesses there are, and so on and so forth. Not as a strategy for getting past race, but for the explicit recognition that we're stand tall and be proud. It is out of that kind of a conflict that comes the current set of concerns and preoccupations with the word quotas. A loaded word. An attempt to get us past the need for black conscious remedies, a recognition that the black community may not want to sit down to dine with me. They want to know what percentage of their community is middle class or whatever. Black pride, black power. You're familiar with this. You're familiar with this. And those are the issues which to this very day have President Bush fighting with the Congress about various civil rights issues. Having moved sweepingly, I am really aware, through, maybe the dean will give us another semester to do this course. I would like it. Let me, as I promised I would, give some hypothetical cases which I have prepared for use by students. And the point of using them is to suggest things for subsequent discussion. You don't have to memorize these for the final examination in this course. 1. Small-town USA has a population, that's anonymous, right? Small-town USA has a population which is 80% black and 20% white. I did that backwards the way I meant to present it. 80% white and 20% black. 20% black. They had a referendum. They don't allow blacks to vote by this referendum. They don't allow blacks to own private property, and they don't allow blacks to run for government office. I mean, that's Jim Crow. So that's just to begin the discussion. The majority may not use race to exclude participation of others from governmental functions, such as running and voting. And that we could talk about, but that would not be controversial and would be very straightforward. 2. Small-town USA runs public bus lines. It's the government. The government runs the bus lines, which for many years have maintained separate sections for smokers and non-smokers. Small-town government now decides to maintain separate bus sections for blacks and for whites. Profound example by me. The obvious point being, it is the government, but they're using characteristics of smoking and non-smoking as distinct from characteristics of black, white. So that leads you to a discussion of is the group characteristic of smoker, and you can think of lots of others, sufficiently similar to race that would be a highly suspect classification, or is it not? Is it sufficiently different from race that it is not a highly suspect classification? Further, tying in with material that we talked about earlier, does it matter if the objections to smoking are on solid health grounds? The Solicitor General says that secondhand smoke can give me lung cancer. Or does it matter if it purely rests on an aesthetic ground? Sir, your pipe is the most vile, stinking object I have ever smelled in my entire life. Separate strokes for different folks. We did all of that last time. We talked about not imposing, or the issues involved in imposing one's taste values as opposed to what looks neutral like health and safety. All right, so you got those two issues lined up in if you can separate smokers and non-smokers. I saw it in this university in a cafeteria this morning. Can you separate blacks and whites, and is it the same and is it different? And does it matter whether it's done by the government or does it matter whether it's done by the group themselves? 3. Private restaurants, then the same cases. Private restaurants, smokers, non-smokers, black section, white section, privately owned restaurants. When does something stop being private and become public? When it has a license. Everything in America is licensed except the ministry and the professoriate, presumably because they are harmless. But everything else, I mean, from barber shops to liquor sites. What does it mean to be a business person in Washington, D.C. if you can't go out to lunch with clients because no one will serve you? Does that make it a public effect? What happens if you go to, many of us are old enough to remember, the sit-ins at the lunch counters, privately owned lunch counters. Yeah, but if there's no place for a black person to eat, he won't travel. And the indignity and the difficulty, and would it be better if there were in the whole world, or now in every city, one restaurant that restricted on the basis of race? Would you then not be so upset? I mean, who cares about one? Does it matter that I do if they tell me I can't come in? How to think about that? Does it matter if there's a pattern, or does it matter if now that we've broken the pattern, there's one? Or five, or how many ever you wanted. Small-town public schools were segregated until a court ordered their integration. Group of black parents does not want their kids to be bused. Black parents. They say, we don't buy into this integration stuff. We want our kids in a neighborhood school. You don't have to be with white kids, Professor Beiser, to be taught. Neighborhood schools are wonderful for us. What we want are black teachers for role models, good teachers to teach our kids, and a black principal. And the hell with your integration. That's your problem, Professor Beiser, white liberal. Not my problem as a parent. That was the position that was taken, and I've done violence to it. That essentially was the position taken by the NAACP chapter in Atlanta, Georgia. They said, the whites are running away anyway. Why do we have to chase them into the suburbs? We want good schools here now for our kids. Our goal is not integration, it is quality education. And come visit Howard University sometime and tell us that you can't have quality education. Separate schools are not inherently unequal. Our black schools may be better for our black children. So an argument developed. The NAACP national office, whatever you do to a local chapter, revoked their license to be the NAACP, suspended their constitution or some kind of thing. The NAACP's position was integration is a positive good. And what was emerging from the Atlanta chapter was education is a positive good, and we don't have to worry about the guilt of the white liberals and letting them send their kids to the schools with us. What do you think about that? How far would it go? How far would you let it to go? One or two more to wrap up. Small-town USA is building a new highway. Highway contracts are highly desirable things to have. No black-owned firm has ever worked for the city of X, a small town, and the companies that do the work have been notoriously slow to hire black persons, whether for hard backbreaking work or for sophisticated engineering work or whatever. Comes the argument, remedy a pattern of past discrimination. Again, remedy a pattern of past discrimination. If a black young man grew up knowing that when his father went to work in the big factory in town, he was subjected to all manner of ridicule and was let apply only for black jobs, sweepers, cleaner-uppers, Stephen Fetchit. Some of us are old enough to remember Stephen Fetchit. He isn't going to come down and try out for a job as a foreman. Affirmative action in the sense of requiring private industry, query, to help remedy the pattern of discrimination which either it enforced on its own or was enforced through the action of the local government. Highly controversial even today, worth serious attention. When is it appropriate to think about persons as individuals? When is it appropriate to think about persons as members of a category? Is the category of race really that different from all other categories such that it deserves its present status as a unique and highly suspect classificatory scheme? After you figure out all of the answers to that question, or in I think 20 minutes, whichever comes first, we will move to similar kinds of discussion of the issue of gender. So one of the things that you might want to reflect upon as we conclude this talk is which, if any, of the arguments and discussions about racial groups and racial classifications apply or do not apply in the context of gender distinctions.